petition become as item number 28 and 29. This matter be taken after petition matter.
On a prayer made by Riaz Bora, learned standing council BTC. Matters are adjourned to be listed after the summer vacation.
28 and
28-29.
In item number 4, we have filed an affidavit.
Mr. Bora, is there any interim order?
In item number 4, we have filed an affidavit. We are under the impression that the affidavit will not be tagged, but already the affidavit has been tagged. But since we have taken consent from senior counsel K.N. Chaudhary, my learned friend is here.
He's
So,
appealing for
matter
getting-
may be adjourned for some other date.
Only the 13, bearing 13 and 16, any date.
You tell us. Item
As per
number?
convenience of
Item
the-
4.
Okay.
Lordship may be 17 of June. Or even in 19th is,
Today is what?
today is 9.
On 16th?
16 he will not be available.
Okay. Then 18th.
Yes, sir.
Okay.
My
On
lord,
a joint request made on behalf of the parties, matter is adjourned to be listed on
18th.
18th, 18/6.
Highly obliged.
Yes.
My lord, I beg to mention for listing of a contempt matter, in
Okay.
orders.
Orders, why?
My lord, it was last listed on 22nd of April, my lord. They are the fixed after 2 weeks, my lord, but not listed.
Fixed matter. Okay, Friday next.
I'm praying for listing one division matter relating to non-payment of salary lot. My lord, may I pray this matter may come on Wednesday lot.
When was it last listed?
And the last listed on 16/5/2025. It ought to be listed after 2 weeks.
What was the order?
My lord, this petitioner lordship,
What was the order on the last date?
2 weeks time was given to file lordship obtain instruction.
16/5.
My lord, we have urgency because petitioner is getting neither the current salary nor the area.
Okay, Friday next. We don't otherwise encourage by memo unless it's very urgent. Yes.
May I please, your lordship? My lord, I beg to mention motion item 5.
Hmm.
My lord, in fact, in this case, we have challenged the rule 14(2), my lord. So, my lord, this matter is required to be adjudicated by the division bench.
Okay. Sri A.R. Bhuya, learned counsel for the petitioners, have submitted that in this petition, the vagaries of certain rules
Well,
have been questioned, has been put to challenge. Good stuff. Therefore, the submission is not, is endorsed by Sri SMT Chisti, learned standing counsel, secondary education, para. The said aspect be verified by the registry and the matter be listed before the appropriate court.
well, obliged.
May I please, your lordship? Sir, I beg to mention item number
Just a minute, the vagaries of the cell and therefore, vagaries of the cell and therefore the matter is required to be listed before the division bench. First, huh? Yes, madam.
item number 16, my lord. My lord, in this matter, my lord, the respondent number 2 has filed affidavit in operation, my lord, and I would like to file reply, my lord. The time may be given for 3 weeks, my lord. I
Okay.
have taken the consent of the other side also.
On a prayer made by MS as Borpatro Guha, learned counsel for the petitioner, 3 weeks' time is granted to file rejoinder affidavit.
No.
Yes.
Okay.
No, is there any interim order? Madam, is there any interim order?
That's subject to the outcome of the request.
Yes.
Okay.
May I please, your lordship? I would like to mention WBC 5854/2024. Lordship, it was last listed on 19/12/2024. It ought to be listed on for after.
What is the matter about?
What do you want?
What is the subject matter?
Selection and appointment of respect to service of teacher of provincialized schools 1003 section.
No, we are not asking the code number. What is the subject matter of the writ petition? What did you challenge? You need to know the basic subject matter. What is your challenge? Why have you come to the court?
Actually, we have filed a writ petition for the appointment of the petitioner as a teacher in the school, namely Sri Krishnan Sarada College.
We are not in the name of the schools. You should be able to tell briefly what is the challenge. What are your grounds? You come prepared. We'll see next tomorrow. Come prepared tomorrow. We'll see whether we can grant you the opportunity to move the matter. Okay, come tomorrow. Yes.
The GIS has not been credited in the account. Till date. It's
Not credited.
not credited. It's sanctioned but not credited.
That was 25.5, I think.
Yeah.
The communication. Yes, what instructions?
Malad, regarding credited, Malad, I have to take instruction because it was sanctioned on 25/5.
Sri B. Purkasta Learned Counsel for the petitioner has informed that this court in the last order dated 26/5/2025 had recorded the sanction of the GIS, the same has not been credited to the account of the petitioner till date. Para? Sri P.K. Bora, Learned Standing Council, Elementary Education Department, prays for some more time to take instructions in this regard. Para? List after 2 weeks.
Plus,
You also take instruction, Mr.
Yes.
Pertaining to item 2, your lordship, notice has not been issued. No, what we, not. Lordship, they were supposed to bring instructions.
What is the matter, madam?
Earlier, we had an instruction, my lord. And latest instruction is, my lord, inspector of school, Baksa could not take a decision in the matter, and therefore he has referred the matter to the director of education, my lord. So today he is on leave, my lord, director. I have been contacting him.
Let us issue notice. It is pending since 2024. Your G. Swami,
Yes, lordship.
heard Ms. G. Swami, Learned Counsel for the petitioner who has approached this court with a prayer for payment of family pension. Full stop. It is, however, it is the case of the petitioner that her husband, who was working as the headmaster of Gurumara Model Primary School in the district of Baksa, had passed away in the year 1999. Full stop. However, due to ignorance, the application for family pension could not be made at that time. Para? Though this matter was listed on earlier occasions and certain instructions were directed to be taken, there is no concrete instruction till now. Full stop. Let notice be issued, returnable by 4 weeks. Let steps three. Yes, madam, who is respondent number 1?
Lordship, 1 is state of Assam, but respondent number 3 is
Who is
the
that? Who is respondent number 1?
Commissioner and Secretary, Government of Assam.
Which department?
Lordship, Commissioner and Secretary.
Which department?
Lordship, department will be
Will be means
pension.
we have to deduce. We'll to infer the department. Madam, don't file petitions like this. High time we have to reject this petition, this kind of petitions. If you don't know whom to arraign parties, how to arraign parties. These are not new matters, madam. If you don't even care, take the due diligence in filing. How do we help you? Help the cause of the petitioner. Yes, State Council. Ms. S. Kaur, Learned State Council accepts notice on behalf of Rest number 1, 2. Director Elementary Education, BTC.
My lord, 3.
3, yes, sir,
Director-
Abha. Training Council, BTC for 3. AG, D. Bhattacharya, Standing Council, AG for 4. 5, B Gogoi, Standing Council, Finance. Let extra copies be served upon them by tomorrow, within two working days.
Highly obliged.
May it please your lordship. In last occasion, my lord, time was given to get the instruction, my lord. And this is how the matter has been listed today. And the matter is regarding provincialization of the services of the petitioners. And the school has been established, my lord.
Your names have been recommended
It's recommended, my lord.
by the which district scrutiny
District level is.
as well as
doing it.
state.
And thereafter, well, nothing was happened. And then, my lord,
Okay, we'll issue notice. Heard Sri M. H. Chaudhary, Learned Senior Counsel, assisted by Sri M. K. Chaudhary, Learned Counsel for the petitioner. One petitioner. Oh, it is the school.
school, my lord, petitioner is school, my lord.
Petitioner whose grievance relates to non-provincialization. Full stop. It is the case of the petitioner that DISE capital code was issued to it, which was continued from time to time on its renewal. And in spite of the name of the school, in favor of the petitioner being recommended by the district's level scrutiny committee, no further action has been taken. Para, let notice be issued returnable by 6 weeks. Education,
Yes, your lord.
Okay.
I'm appearing 1,
Okay.
2, 4, and
Ms. P. Das,
4.
Learned Standing Council. Secondary,
yes, your lord.
secondary education, 1, 2, 3, and 4. 5, states, Assam State Schools Education Board, SIBA, DK Roy. 5. Let extra copies be served upon them within 2 working days.
Highly
Returnable question, 6 weeks. Item 6, Purkasta.
My pleasure. In this case, my lord, the petitioner has been, my lord, disqualified for the post of headmaster promotion, my lord, on account of, my lord, he was not having the NOC at the time of procuring her B.Ed degree, my lord. And this honorable court has already settled this issue on many occasions.
Heard Sri B. Purkasta, Learned Counsel for the petitioner whose grievance relates to his his disqualification
Yes,
from the consideration for promotion to the post of headmaster. Full stop. He has submitted that the grounds assigned, namely non-obtaining of NOC for obtaining the B.Ed degree, has already been the subject matter of litigations earlier, which has been set aside by this court. Para, be that as it may, let notice be issued returnable by 4 weeks. If it is covered, we'll 4 weeks, short notice, 4 weeks. B. Kaushik for 1, 2, 3, all the respondents, 1, 2, and 3, extra copies.
and one interim order I'm praying, my lord, there in other cases, my lord, one post should not be filled up in respect of the petitioner's district, my lord.
Your
Page
lordship
number 40 is the similar order as annexed, my lord. One
will-
fifty.
Here, my lord, the petitioner assumes that by virtue of annexure 15, his name has been dropped. Now that's issue. That issue is no more res indica that B.Ed without having the NOC, the B.Ed will be invalid. However, my lord, the petitioner in his writ petition nowhere disclosed that when he got the graduate scale of pay as per rule 14, he need to have 10 years of graduate skill of it.
Okay,
So prima facie,
okay, Sri Purkasta prays for an interim order and has submitted that in similar matters, interim order has been passed. Para. On the other hand, Sri Kaushik, the Learned Standing Council, has submitted that apart from the issue which has been raised now, there are other criteria also
Well.
on which there is no averment in the writ petition, full stop. He therefore submits that interim order is not called for. Para. After hearing the parties and by balancing the equities, it is provided that one post of headmaster be kept vacant if kept vacant till the returnable date, full stop. However, if it is found that there are other criteria which the petitioner has not qualified, comma, the interim order shall not be operative.
This is the same to my lord, item number 7, 8, and 9, my lord.
7, 8, and 9.
Yes.
Okay, 7, 8, and 9.
Obliged.
Other criteria, other than the NOC for B.Ed. Clear করে
Obliged.
একটু ভাবকে ফ্রেম করে দিবা, হ্যাঁ? Yes, Mr. Bhagavati?
Lordship, we have got the result yesterday evening only, Lordship. He had been declared first with 20 marks in the practical exam.
You told last time also,
Lordship.
indicated. Now,
Lordship.
Lordship, I have received the instruction that school, as per the Lordship circular, CBSE circular, actually they have to upload the marks from between 1-1-25 to 14-25, the school authority. But they have not uploaded the mark. They have they informed the CBSE only on 6-5.
much later.
Much later, and CBSE immediately sent everything to the Delhi office, and Delhi office has corrected the marks on 13-5. That's it.
Okay.
So he would have get the admission in Cotton College also, not. I have told my friend that you give me the number.
Just now she told me, Lordship, that
Yes.
this is the thing.
Yes, you
Lordship,
give me.
now what happened, Lordship? They have to upload the mark sheet along with the application. They have a new portal, Higher Education. Lordship,
There is a portal, Lordship.
there is
Now,
a
how-
portal,
how-
Lordship.
You tell us how can it be resolved?
Come
You said 19th is the last
That
date.
is
Lordship,
DG Locker. DG Locker.
Lordship, they are, Lordship may go for this, Lordship.
No, what can be done? Tell us.
Lordship, the director can take up the matter, Lordship, and upload the mark sheet, Lordship. We have uploaded the mark sheet which was written
Yes,
compartment.
Mr. Das? Hmm? No, director, he says.
Lordship, they can do it, Lordship. This is a new, Lordship, they are going to open.
Already marks have been uploaded. He said to mark.
No, that is not required. That is not required. No, if you say the
Lordship,
director can perhaps play some role.
Lordship.
Mr. Das, we'll have this matter day after tomorrow. Today is 10th, 9th. Day after tomorrow,
Lordship,
we'll have
Lordship,
this.
Lordship.
Okay.
Because we have uploaded the marks. Lordship.
We have a prayer also, Lordship, on that regard.
Original mark sheet, that will take some more time, so the student can get admission with this mark. We can.
Okay, good.
Yes. Good. Metric.
But your entire foundation was on the allegation that CBSE has not done their, but that CBSE has
Lordship,
done.
that we didn't know, Lordship. Just
No, there is a lack of due diligence from your part. Madam says it was done on 13th.
Yes, 13-5.
13-5.
Mark sheet, Lordship.
You had approved this code on 29/5.
Lordship.
This is the mark sheet.
What can be done?
Lordship, let them try, Lordship, once if they try.
No, no, we are concerned of the future of the student.
Lordship.
Yes.
But you need to be vigilant. You are facing
Lordship,
such.
that is true.
They
That's
should
why I
have
agree,
sent
Lordship.
directly to the CBSE, then they would have,
Oh.
they got that information.
In fact, they have written to the CBSE also, the father of the applicant, Lordship. I have placed it in the, in my case, Lordship.
But if it was out on 13th, that too on the public domain, you should have known. It was uploaded.
Yes, they'll check the portal also. That is called DG Locker.
Heard.
DG
Sri M.
Locker.
Bhagavati Learned Counsel for the petitioner.
No,
Passing of 12, he is going to take admission in degree.
degree, Well, high school has not uploaded anything now, they are saying like this.
Also, we can do it. I know.
Heard Sri M. Bhagavati Learned Counsel for the petitioner. Who has approached this court with the allegation that the CBSE had failed to take appropriate action for
Result
declaring the results of class 12 for which he is not in a position to
13.5
take admission in the degree course. Full stop. It is the case of the petitioner that there was some glitch in uploading the marks in the practical paper for which he was marked absent in the said paper and the results were declared to be compartmental. Full stop. It is the case of the petitioner that he had appeared in all the papers, including the practical paper in the concerned subject, which was subsequently acknowledged by the school in question, and the matter was informed to the CBSE. Para? On the last occasion, that is 4/6/2025, this court had passed the following order, 4/6.
Lots of one thing,
Can I get?
lots of results were declared on 6th June. On 6th June, lots of we got this compartmental result. Lots of. 13th May, we got compartmental.
No, not 6th June, not 6th June. It was in May. Following order, para.
Result কেতিয়া
Miss
পাইছে? জুনত দিয়া নাই।
R. Bora, Learned Standing Council, CBSE, has however submitted on the basis of written instructions that the matter was duly considered by the CBSE and the results of the petitioner was declared and uploaded on 13/5/2025 itself, and therefore there was no cause of action to be espoused on the date of filing of this writ petition, which was on 29/5/2025. Full stop. Para. Sri Bhagavati, the Learned Counsel, has however submitted that his client was wholly unaware.
On 13/5, we got the compartmental mark. Although they said that is the declaration.
Wholly unaware of the said development, and rather on 13/5/2025, the results with compartmental in the concerned subject was received, was made known to her. Full stop. Para. Be that as it may. In an attempt to resolve the issue, this court directs Sri S. Das Learned Standing Council, Higher Education Department, Secondary Education Department, Higher Education Department, to take instructions from the Director of Higher Education as to whether the results
can be uploaded in
Which-
Sarat.
which has already been declared on 13/5/2025. Well, whether there is any scope to upload the results in the portal,
Portal.
in the concerned portal, so as to enable the petitioner to take admission in the degree course, the last date of which is 19th. 19th.
Lordship, last date is over, Lordship, they are again issuing a second merit list, Lordship.
Which,
On
the
14th.
extended date of which is fixed on 19th.
Lordship.
What's the para?
14
14th
to 18, Lordship.
is fixed between 14 to 18, 19,
Okay.
14-18. Para. Let this matter be listed again on today's 9th, on 12th,
By the verdict.
the 11th, okay? Let a copy of this order be served upon Sri Das during the course of the day to enable him to obtain the instructions. Okay, you can write the letter now itself, based on the, okay, will you have a copy, please collect it from the court master.
One thing is there, the corrected result which is available in DigiLocker and
Easy Locker is different thing, like personal, Lordship. They have to upload in the Sarat. It's the different portal,
I'll
Lordship.
take the
Of higher. She can also take the inspection.
Okay. Try to resolve all of you.
Lordship.
Madam Bora,
yes.
whatever is
Lordship, Lordship.
future of the student is
Lost
there,
it,
only on that consideration. Otherwise, there is lack of due diligence on your part.
11 to
11
March alert.
of like
60 and 61.
This matter may be taken up on Friday, man. Say I have some problem.
Why?
Friday,
How can you file two matters, two writ petitions?
no, my lord, this is my lord challenging the my lord office memorandum, latest office memorandum,
Which one?
present one.
What is the first writ petition? Why haven't you disclosed the filing of the first writ petition?
It is disclosed, my lord.
Where?
Somewhere it is mentioned, my
Let
lord.
us see. Let us see.
My lord, today I saw, my lord, because last occasion, my lord, another advocate appeared, my lord, and
I don't know, petitioner is the same.
yes, my lord.
You cannot abuse the process of the court like
No, no,
this.
definitely, my lord, there is a mention. Nevertheless, my lord, this is a new matter challenging the circular, my lord.
But I have to disclose that you have
It
already.
is, it is disclosed there, my lord.
Huh?
Though it is a fresh cause of action, my lord, but this is also there, my lord. This is separate, my lord. This is
We'll have it day after tomorrow.
my lord.
Both the matter be taken up together.
Together, obviously, huh? Yes. Both these matters have been listed together. On the basis of an order dated 6/6/2025. Full stop. Today, Sri A.M. Barbhaiya, learned counsel for the petitioner, has prayed for some accommodation and has also contended that in the subsequent writ petition, there is no suppression.
No, but after the suppression is in another my lord cause of action.
No, you have said that there is no suppression of filing.
My lord, I am not my lord, verified right now.
You
my lord,
are,
petition.
till now you are saying that you have disclosed. You said twice,
My lord,
not once, twice that you have disclosed filing of the.
it is I my lord submitted then it must be my lord.
Must be what must be?
My lord, my submission is that my lord, it is separate case. My lord.
We are not on that. We are on the disclosure part.
Yes.
Don't.
But matter may be taken after some time. My lord, I verify the brief file.
We are having it day after tomorrow.
Yes, sir. only my lord, just my lord, may be listed after tomorrow.
কি কলো এম বৰভূঞা? That he is not certain regarding the aspect of non-disclosure.
Well.
Full stop, para. Approach to a writ court, which is a court of equity, without disclosure, without candid disclosure, would not be encouraged at all. Full stop, para. Be that as it may. List this case, list these two cases on Wednesday. এইটো মই 1-2 মাৰা আছে কিন্তু বিপ্লৱে কিয় হেৰি নকৰিলে সাইন নকৰালে কিবা কৰিছে পিছত নাজানো দে দেখুৱাচোন এইটো yes next
May I please your lord?
you have not taken steps.
Lordship, the respondent number 9, Lordship, is supposed to take steps. We have missed out.
The similar case is already been passed order by the Honorable Court.
If the matter is pending before the education tribunal, similar case. Otherwise, Lordship, the
Similarly situated person have already been appeared before the tribunal as per court order.
same
9 new to right.
secretary, school management. Secretary.
Yes, what about 9?
Lordship, 9 is the secretary of the school managing committee.
You are for the school.
No, I am for the rest, private.
Then 9 needs to be served or not?
Lordship, otherwise he is the secretary of the school managing committee. If the
If he
main
has a-
action herein is against respondent number 8, Lordship.
But if 9 has a role, he needs to be served. You have made him party.
Lordship, then allow me to take fresh steps. I'll take
Okay.
steps hereafter, Lordship.
My lord, similarly situated person have approached this honorable court, madam, and they obtain the order. So lordship can pass that order because it is stated that they should go
Which
to
order?
tribunal.
Tribunal, Lordship.
You should approach the tribunal.
Lordship,
Yes,
You can approach the tribunal.
Lordship, that may be passed.
That Umolota is also one of the
But what about the limitation, madam?
already
Limitation,
Umolota. Petitioner, he has already been approached before. Tribunal, madam. It is going on, na? তোমালোকে তুমি হয় নাই মোৰ এই নহয় আগতে Umolota.
Now, what about the limitation aspect?
Actually, non-provincialization of the
that
of the petitioner and respondent.
We are not on the cause of action, madam.
Yes, ma'am.
Is there any limitation to approach the tribunal? This writ petition is pending since when? 2021.
2021.
We are in 2025.
Lord.
Tomorrow she goes. Tribunal says that it's barred by time.
Yes.
So we want to know what is the limitation.
Aynı ki adına second say.
You cannot approach at any time.
Right.
There has to be some. Within 3 years, but this writ petition is itself pending since 2021, 21. We're in 25.
Passing the order, they will get the 3 years, my lord, after passing the order. কি কৰিবা press test over.
Though this case has been listed under the column, orders no steps, comma, considering the subject matter involved, and as agreed to by the learned counsel for the parties, the same is taken up for disposal today itself. More so, when this matter is pending since the year 2021. Para? Without going deep into the merits of the dispute, the challenge in this writ petition is with regard to the provincialization of the services of the respondent number 8 in the, what is the name of the school?
Malaram Pegu High
In the Malaram Pegu High School in the district of Lakhimpur. Full stop. It is the case of the petitioner that the said respondent number 8 is junior to him, both from the date of appointment as well as joining. Full stop. Para. I have heard Miss A. Talukdar, learned counsel for the petitioner. I have also heard Sri P.K. Bora, learned standing counsel, Elementary Education Department, semicolon. Miss D. Das Burman, learned state counsel for the official respondents, and Miss K. Devi, learned counsel for the respondent by 8.
7 and 10.
Not 8. For us, 8 is not before us.
No, Lord.
Nobody is there.
7 and who are 7 and 10?
7 is Girindra Pegu, and
Who are they?
they are also teacher, my lord.
But you
7
are
and
only
10.
challenging 8.
8, yes.
Why 7 and 10 made parties?
Lordship, he's the headmaster. 7 is the headmaster of
You
the
made him
school.
by name.
Lordship.
So 7 and 10. Full stop. Para. The learned counsel for the parties have, however, pointed out that the dispute which has been raised with regard to provincialization is required to be adjudicated adjudicated by the Educational Tribunal, in which has been constituted in terms of the 17 Act.
17 Act.
Name of the Act?
Provincialization and Assam Education.
As per the Assam Education Freedom Act,
Like-
provincialization of services of teachers and reorganization of educational institutions, bracket,
Act
close
2017.
Act 2017.
17.
It pays 22, judgment to return. Full stop. Ms. Talukdar has, in fact, placed before this court a copy of the order dated 2/4/2024, passed in WPC 6674 of 2022, where in a similar situation, the matter was remanded to the concerned educational tribunal. Para. In view of the above, this court is of the opinion that when a specialized tribunal has been constituted in accordance with law, which can go into the facts of the case, interest of justice would require remanding of this matter to the said tribunal. Accordingly, the petitioner is granted liberty to file an appropriate appeal.
Appeal.
Is it an appeal?
Yes, appeal.
Appeal before the educational tribunal, espousing her cause, espousing her grievance. And on such approach, the learned tribunal shall decide the matter in accordance with law, which in accordance with law, full stop. Since it is made clear that while disposing of this writ petition, no opinion is expressed on the inter se merits of the parties involved. Writ petition accordingly stands disposed of. It is further made clear, it is further made clear that since this matter was pending in this court since the year 2021, the aspect of limitation, comma, if any, shall not be taken as a bar for such approach. That's dispose of. Yes, next.
Highly
Much
obliged.
obliged, sir.
11.
Yes.
We are taking steps.
Hmm? Which one it?
In fact, my lord, by the interim order, the initial order, my lord, 1/4/2022, Lordship may see parasite. The state level security committee, scrutiny committee was to do the inquiry, my lord. So that is still pending.
Follow to that information I do not have. Regard to the sectors of the.
Who is respondent number 6?
Respondent number 6 is, my lord, headmaster, 920 number high school, my lord, LP school.
Oh.
We have taken steps on 12/10/2023, earlier, my lord. And 8 is the, my lord, the association, my lord. But now they have shifted their office. So we are trying to collect.
This court, by the order dated 16/2/2024, had directed the registry to put a note as regards the status of the service report of notice upon the respondent numbers 6 and 8. Full stop. The learned Lawazima Court, however, by the order dated 10/6/2024, had no, by the initial order dated 23/4/2024, had directed the petitioner to take fresh steps for service of notice upon the respondent number 6. By registered post with AD, as well as by usual process. And in so far as the respondent number 8 is concerned, the petitioner was directed to obtain instructions regarding the present address. Full stop. Para. However, it appears that such steps have not been taken. Para. On the prayer of Sri J. Roy, learned senior counsel for the petitioner, comma, 2 days time is granted to take fresh steps on the respondent number 6 and 8. Full stop. However, such steps are to to be taken in the, only in the mode provided by the initial order dated, initial order of this court dated 1/4/2022, and not by the usual process. Full stop. It is further clarified that unless the court specifies the mode, comma, the aspect of issuing of notice should not be the subject matter of consideration by the learned law Zimma court. Full stop. Para. List after. The fresh steps upon the response number 8 is to be taken on the corrected address. Para. List after 6 weeks with fresh service report. Full stop. By the said time, Sri B. Chaudhary, learned standing on the SSA, shall obtain instructions with regard to the order, initial order of this court dated 1/4/2022.
Obliged.
Yes, Mr. Talukdar.
May I please, your lord? First, I have received all my entitlements, lord. So matter may be closed, lord.
Okay. Sri H. Talukdar, I heard Sri H. Talukdar, learned counsel for the petitioner. Also heard Sri P.K. Bora, learned standing counsel, Elementary Education Department. Full stop. Tara. The petitioner had approached this court against the action of the respondent authorities to attempt recovery from his pensionary benefits of certain excess payment made to him during his service. Full stop. The petitioner had retired as the headmaster. The petitioner, the husband of the petitioner, had retired as the headmaster of 1758 number NO, Balatari LP School in the district of Borpeta. Full stop. The petitioner had earlier approached this court for family pension by filing WPC 3859 of 2020, wherein an order dated 27/2021 was passed, and no, wherein an order dated 1/9/2020 was passed, pursuant to which the family pension was sanctioned to her. Full stop. Sri Talukdar, the learned counsel, has however submitted that during the pendency of this writ petition, the grievance of the petitioner has been redressed. Para. Sri P.K. Bora, the learned standing counsel, Elementary Education Department, as well as Ms. D. Das Burman, learned state counsel, have submitted that in view of such development, there is no requirement to continue with this writ petition. Full stop. Para. Considering the aforesaid facts and circumstances and the submissions advanced by Sri Talukdar that the grievance of the petitioner has been redressed in the meantime, there is no requirement to continue with this writ petition, and accordingly the same is disposed of. I had to agree. I already disposed of it. Item 13. IA4?
My lord,
IA4?
for order, that means we have, according to this note, my lord, we'll have to serve extra copies. We have to serve one copy. So we'll give, your lord will give us, to this time, we will give extra copies to them.
Yes, sir. Well, the copy will be furnished to the council, my lord, with company. Otherwise, my lord, this become infrastructure. Like, my lord, same petitioner, about 5 cases were listed. 4 was, my lord, dismissed because it has become infrastructure. This matter, my lord, was
For some time and my lord, it got segregated from that, my lord.
That is number one,
The
that is
police will
under
say-
appeal. That is in under appeal. And my case is totally different with those cases. I'll
Or she will fix it
convince
after
your
1 week, my lord. I will place the order. It has been all cases have been,
Okay.
because there is a change of policy.
3AC Buraguha, Learned Senior Council submits that extra copies of the writ petition which was to be served could not be done due to inadvertence, which, full stop. He however undertakes that such copies would be served by Ms. J. Tamuli, who is assisting him. Full stop.
Copies of the IA to be funded.
We are writing in the IA only. Huh? 3 Gogoi, the Learned Standing Council. This is Health and Family Welfare Department has however contended that there is no live cause of action to be.
That is not
And-
necessary,
no.
my lord, because we don't go to
His contention we are recording
Yeah.
has contended that there is no live cause of action to be adjudicated and similar writ petitions have been dismissed as infractuous. Full stop para. Be that as it may, let extra copies of the IA be served upon Sri Gogoi during the course of the day, and the matter be listed for consideration after a month, after a week.
After correspondent to it.
Who is to? Assam's? ASTU. Oh. You are D Gogoi. D Gogoi is present for respondent to ASTU. Copies to be served to you also.
Yes,
Oh.
yes.
No, which copy you want? I.
Madam, please give extra copies during
Fine.
the day, during that course of the day.
Fine.
We'll have it on Wednesday next, Mr. Gogoi. List on
Let it in next.
next week, next
next-
week,
next-
not this week, next
Mm.
week. 18. 18 to 17, 18. Mm. Mm.
Yeah, please, Lordship. Lord, petition for my lord, correction for date of birth in service book, my lord. And the matter is pending, my lord, before the, my lord, Commissioner Secretary Elementary Education, my lord. Kindly turn to page 33, my lord.
Hmm. Now, what is the position now?
My lord, that has not been considered, my lord. So it should be disposed of, my lord. It is pending before the, my lord, Commissioner Secretary Elementary Education.
Yes, elementary, Mr. Sharma. When did you retire?
My lord, by this, my lord,
You're retiring this
year, my lord,
this month.
this year, my lord.
When did you file the application for correction?
My lord, it was filed, my lord, in 2014, my lord.
Correction,
My lord.
2014.
Yes, my lord.
Where is your application?
My lord, page 13 and 13, it was forwarded by the, my lord, DO, my lord,
13,
my lord, page 33.
33.
Yes, my lord.
Yes. 14. Yes, he's retiring this month.
This year.
This was given for 10 years, a decade earlier. It was given to the district elementary education officer, to the commissioner. Yes, madam. Now we cannot take up the plea that fag end of the career. He has come at least a decade before his retirement. You have not considered, or you have considered, if you have considered, you should place it before the court that it was either rejected or accepted. It could not have been accepted. He would have known, maybe rejected.
Well,
but you should inform him.
Why don't we take it next week? I will take it.
All this time, what were we doing, madam? That was pending since the year 2021. Your SH Sigdar.
my lord.
Part three, SH seek the learned counsel for the petitioner. Who has informed this court that the petitioner would be retiring in this year, and his application for correction of date of birth in the service book was submitted way back in the year 2014, correct?
Well.
14, para. Miss Ash Chutia, Learned Standing Council. This is what? Education?
Elementary.
Elementary Education Department. Prays for some time to obtain instructions. Para. Considering that this writ petition is pending since the year 2021, a week's time is granted to enable her to obtain the instructions. List on Wednesday next.
Right.
We'll have it on 18th.
Hello.
Yes.
In this case, my lord, elementary education has filed their affidavit in opposition, my lord. We have actually admitted the case. My lord, the petitioner was appointed the stipendiary teacher on 31.
Mr. Khatania, what is your?
Well, it is covered by Minati Posthumotis case as Purnima House.
Well, here, well, he has been given the benefit of pay scale in the year 2015. Well. Though in the 2001 letter, it has been mentioned as regularized, but in that order, only a stipend was of 800.
Is it covered by the earlier decision?
Yes.
Well, because he was not initially appointed as stipendary teacher. He is a teacher of Monomoran committee.
Whether it's covered or not, if you say it's not
That
covered,
I have regarding that.
if it's not covered, we'll hear you. If it's covered.
Regarding that, Purnima Hore case, I have to go through it, because in the peculiar fact of circumstances, whether it is
Okay,
covered
day
or
after
not.
tomorrow,
Yes, my lord.
we'll try to on Thursday.
Thursday.
On Thursday, we'll dispose you on Thursday. Oh. Sri BJ Ghosh, Learned Counsel
Well,
for the
Thursday may be
petitioner.
on difficult on my part. my lord.
Tell us whichever day.
Next Tuesday, my lord. Or
I am not.
Wednesday, then day after tomorrow.
day after tomorrow. Day after
Day after tomorrow. Sri BJ Ghosh, Learned Counsel for the petitioner has submitted that the issue involved would be covered by earlier decisions of this court. Para. On this aspect, Sri N.J. Khatania, Learned Standing Council, Elementary Education Department, prays for some time to examine the said aspect. Aspect to examine the same. Para. In view of the above, matter is adjourned to be listed on listed day after tomorrow.
Yes, sir.
Date
How will I do?
11, on which date an attempt would be made to dispose of the writ petition.
Lordship.
Item 17.
May it please the Lordship. Lordship, we have received the affidavit in opposition of the respondent. We pray for 2 weeks time to file the rejoinder.
Yes, Mr. Upamanu.
Where file?
Dr. P. Agarwal, Learned Counsel for the petitioner, prays for and is granted 2 weeks time
2 weeks.
to file rejoinder affidavit. Sri D. Upamanu, Learned Standing Council, Health,
Higher
Higher Education
Then forward.
for
Nahakatia College, not
Dibrugarh.
Nahakatia College.
Give,
Kolkata.
give your name.
Number 3 and 4.
For 3 and 4 is present, are present, huh? Do it actually. Madam, give your name, please, okay?
Obliged.
18.
Please, Your Lordship.
So, but does it will
Hmm?
be ready to send, it is sent for waiting
Affidavit.
to some time.
Item number 18, 23 matter, file on time, already you are delayed.
Already have sent it for waiting.
On the prayer of Miss Anne Fukan, Learned Standing Council, Elementary Education. No, don't like this. Miss Anne Fukan, Learned Standing Council, Elementary Education Department has submitted that the affidavit in opposition has been prepared and sent for vetting. She accordingly prays for and is granted 10 days time to file the same.
Yeah.
Okay. Yes, next.
We are directed to receive records. but
Got the
we
records or
haven't
not?
received any report.
What records?
My lord, our cases, we were initially appointed in the year 1994. We received salary for some time. In the year 1997, we approved this honorable court, and this honorable court directed for release of our salary after verification.
Hmm.
Thereafter, my lord, our cases were being processed in a particular file. In the petition, we have mentioned the file.
When was it?
My lord, therefore, we have filed a separate IA.
No, no, when was it done? This file, when was it opened?
Well, before the government by the judicial department.
When?
2003 itself.
And you have approached this court in 2023.
Because our services were regularized in the year 2021 with effect from 2020. During this matter, there was some direction passed by this honorable court. Government
Now, how do you reasonably expect to trace out a file, 20 years old file?
if there is no record, then they will apprise before this honorable court. Then on the basis of the available.
You should be, see, you have approached the court.
Yes.
You cannot just burden them that you trace a file of 20 years.
They are taking time, my lord. If there is no record, my lord, they will say, my lord. Otherwise, it's our prayer, my lord, people will.
On the prayer of Ms. and Fukan, Learned Standing Council, elementary education. 2 weeks further time is granted to take steps pursuant to the earlier directions of this court. And Fukan and Nagaon.
So in this case, my lord, as per number 4, file an affidavit, my lord. I have to file rejoinder affidavit. 1 week time will be granted.
Your name?
K. Kolita.
Huh?
K. Kolita.
Item number?
20.
You are not on record. You are not on record.
My lord. On behalf of ISTK, my lord.
Okay. On the prayer of Sri K. Kolita, Learned Counsel appearing for the petitioner, 2 weeks time is granted
Lord,
to.
kindly fix the date. They try to delay Lordship.
Okay, we'll give a date. 2 weeks time is granted.
Lordship,
to-
only 1 week's Lordship. Kindly, only 2 months left Lordship service.
When did you file your affidavit? Oh, they have
Yeah,
filed in
affidavit, Lordship.
24, they have filed affidavit, 12/24. We grant you 10
1
days
week,
time.
1 week.
They are,
Okay, 1 week. A week's time is granted to file the rejoinder affidavit. Para, as urgency has been expressed on behalf of the SP number 4,
they are illegally upgraded Lordship.
list this matter on was the 9th? No, we'll have it on 17th.
All right.
You file it before 17th.
Yes.
Highly blessed.
All these cases are analogous because arising out of same facts. They were appointed as stipend teacher in BTC area. Their service was terminated and termination was set aside by the honorable court. Thereafter,
Terminations were set aside.
set aside.
Okay.
And thereafter again regularized the service in 2015. Thereafter again regularized in 2022. And they have taken an undertaking, that should be given undertaking that they will entitle for new pension scheme. We have challenged this order that we should not be giving the new pension scheme. We are getting the GPF account and everything. We should get the regular pension as per earlier. We are appointed in 1999. And this honorable court, 4 cases has been filed for the same facts. 1 case has been disposed of, directing the authority to give the regular pension scheme as per old pension scheme. This is the order.
Madam Bhattakur, what do you say? Is
Lordship,
it covered?
Lordship, there is a big TV
with the writ petition number 6020 of 2017 by the name of Ganesh Nursery. Lordship, there are around 44 matters where similarly situated persons have filed for the exact same prayer. And Lordship, the matter has been reserved for judgment on 15/5/2025.
What about this Rupak Kolita?
Lordship, this submitted is correct. This is not regarding the pension. This is regarding area salary filed by some person of BTC area for area salary for a specific period. This is regarding pension, Lordship.
What about Rupak Kolita, madam? Have you gone through Rupak Kolita?
Lordship, actually, I'm unaware of that case.
You go through this. We'll have we can have this day after tomorrow.
Lordship.
Day after tomorrow, are you comfortable day after tomorrow?
Lordship, we are actually also willing to file an affidavit for this.
No, if it is covered, there is no
Already-
question of disputing. If it is not covered, then we'll definitely give you a hearing, okay?
Already analogous case,
okay.
in Rupak Kolita, they have filed an affidavit.
Sri S.K. Goswami, Learned Counsel for the petitioners in these cases has submitted that the issue has already been resolved by this court in WPC, by an order dated 17/2/2025, passed in WPC 3779 of 2023. Para. Miss A. Bothakur, Learned Counsel appearing for the BTC,
Lord.
has however submitted that some time may be granted to her to examine the said order passed by this court. Para. In view of the above, the consideration of this matter is deferred to Wednesday next. Wednesday, day after tomorrow. You can hand over a copy to her or give her the details. She can have a look.
Lordship. Today itself, I'll give a copy.
You have an extra copy?
Lordship, yes, I'll give.
No, this one?
Lordship, this one is available in the record also. Already earlier, I have given to the court. In the court file also, it is available.
Just a minute. Just check. Yes, it is there. You can take it back. Ask it.
Highly okay.
24.
But in this case, they have filed affidavit, manner. I would like to reply.
Who has filed affidavit?
I'll
Lordship,
respond.
secondary education respondent number 2. We have filed our affidavit on 4/6/2025.
4/6. Heard Miss K. Devi, Learned Counsel for the petitioners, as well as Miss P. Das, Learned Standing Counsel, Elementary Education, Secondary Education Department, who submits that on 4/6/2025, affidavit in opposition has been filed. Para? On the prayer of Miss Devi, the Learned Counsel for the petitioner, 3 weeks' time is granted to file rejoinder affidavit.
Obliged. I'm deeply okay.
List after 3 weeks.
Deeply okay.
25.
Yes, this honorable court by order 5/25, my lord. I was directed to file an affidavit whether any post is lying vacant or not, my lord. There is one post is lying vacant, my lord.
You have filed affidavit?
Yes, my lord.
Okay,
Paragraph 4, I have stated, my lord.
okay. Yes,
If it is, they agree to give us appointment, no problem.
I cannot agree.
No,
to
see,
the
the-
direction, I can, my lord.
see,
Because I am selected candidate, my lord, I am
That is
selected.
fine. That is
I am
fine.
selected,
Mr. Day,
lordship,
the instructions were on the aspect whether post is lying vacant.
right.
Yes.
Instruction is not on the aspect that whether they are going to give you appointment.
That is true, lordship.
If he is willing to give you appointment, we'll be the most happiest person.
It is,
At least
Right.
one case, the burden will be gone. Otherwise, you have to decide this case also.
lordship, actually, I am the selected candidate, lord.
For which post?
Grade 4.
Is there any defect in the selection, Mr. Mukhtar?
No, nothing.
But only one problem is that he was selected for the roster point 18, my lord. But unfortunately, that post was already filled up by the government, my lord, by way of professional appointment, my lord. Subsequently, it came to the light, my lord. The then principal issued advertisement. Accordingly, he applied also. He was selected also. That is true, my lord. But now it has come to notice that that post was already filled up, my lord. And we our college also sent proposal for his appointment to the director, my lord. They have rejected it, my lord.
Last annexure of this affidavit, my lord. They have to
Yes,
take-
Director. Even if you are
He-
willing,
he agrees,
Director may still say, we cannot.
Section, count of roster point. Roster point, because the proposal was sent by the college for roster point 18 by the. Whereas 18 roster point is already filled up. But the proposal was rejected. Now, college. Correct.
Proposal for 16 is also same, man. 16 is under process, man. Because the separate proposal was there, man. 16 proposal is under process in the before them, man.
18 is for what? 18 is for what, Roster?
And is all unreachable, but 16
My lord,
unreachable.
16 and 18 is same post, same everything same.
No,
Even
no,
notice-
category.
category also unreserved.
Then what is the problem?
And 18 is, my lord, 18 secured the highest mark, then this is 16. The petitioner secured highest mark in both written and viva voice.
No, no, we are on the roster point.
Roster point is, it is only for the namesake of this title, roster point 16 and 18. Otherwise, everything is same, lordship. It is also grade 4, it is also grade 4. Here it is also unreserved, it is also unreserved. Nothing difference, lordship. Only they have given the names of the 16 and
But
18.
for 16, Mr. Mukhtar, for the roster point 16,
Hirokjyoti does it.
No, no.
Selected, man.
Somebody else is
Somebody else
selected.
is, my lord.
Is he a party here or not?
He is the party here.
These were separate selections.
Yes, yes. ma'am.
But same day examination was held same day, same question paper, everything is my lord same. Nothing different between.
One examination.
Yes. Same day.
No, no, if it is one examination, how does it make a difference?
Yes.
Mr. Mukhtar, Mr. Das, if the examination is one, selection is one, how does it make a difference?
But there is one problem, but separate select list was prepared for each of the roster points, my lord. That is the.
But based on the same selection.
Same
That is
selector.
true.
My lord, myself,
Already filled up.
No, did he, in his application, will he be in a position to specify that I am applying for 18, not for 16? That
Yeah.
cannot be the case.
Not its fault.
Now we have to fill up 16. Now for 16, whom are you going to contemplating to fill up with?
Hirokjyoti Das has been selected.
Why? Same selection, he got more marks.
yes,
But a point per selection was made, my lord. Point per selection, that is the difficulty, but because the names are different, my lord. For selection, 16 names difference are there, different names. 18 different names, my lord, different list. Totally different persons, my lord.
everything is same lordship. Selection
No, it
process.
have easily disposed of, but we are only thinking of the person at the selected person against 16.
And it sometimes file if it because the other is one computer is not it's the this can be taken by order method and just data here also file one bit.
Is it? Why, do you have the details?
I have one order.
No, the details. Writ petition,
Case number is
case number, okay, okay.
My lord, that part is not related with this petition lordship. That part is already over.
Mr. Day, we are doing it to for your benefit.
Lordship.
We want to pass orders in their presence, otherwise making them parties and passing an order in your favor, affecting their rights.
Lord.
Tomorrow it will be difficult
ma'am.
for you.
Lord.
So we'll have both these matters. Then you can, if you have a good case now, you'll have a good case tomorrow also. Heard Sri DK Learned Counsel for the petition. Also heard Sri S. Das, Learned Standing Council Higher Education, as well as Sri S. Mukhtar, Learned Council for response number 3. Para. Sri Das, the Learned Council, has informed that there are two petitions or one petition. Mr. Das? There are,
Those petitions are not pending, my lord.
huh?
Those petitions are not pending now. ma'am.
He says it's pending.
No.
This is For affidavit, time for affidavit, I'll
Not affidavit, what affidavit? 24 matter. কি করলো? না, informed has informed that certain writ petitions were earlier filed by other candidates. Put up. He accordingly prays for and is granted 2 weeks time to file affidavit in opposition. We put a date list on 25th, 25/6.
Lot of like.
And if any cases are pending, kindly bring it to the notice of the court.
Actually, Lordship, no case is pending, that is already dismissed by this honorable court.
I think those are dismissed. Where is the bar?
Yes.
We thought that those are pending.
Yes.
Okay, 25th too.
Oblige, Lordship.
You try to bring those dismissal orders, copies.
Oblige.
26.
This is Rob. Lordship, this is also same matter like item 18, where government and private correspondence, but that we filed an affidavit.
You'd like to file rejoinder or what? Oh, you are supposed to file
File
affidavit, not
affidavit,
file.
Your Lordship, not file, Your Lordship.
You filed two further writs.
Yes, Your Lordship.
On the prayer of Miss P. Das.
Acting is served upon us, Your Lordship.
It's not been served.
Number 22.
It was served perhaps. This is his copy. Why do you take his copy?
Your Lordship.
Huh? You have already put your name. Possession taken.
Lordship, I have handed over.
Symbolic possession. Okay. On the prayer of Ms. P. Das, Learned Standing Council. Elementary education.
Secondary education.
Secondary education. As well as 3 Atia for response number 4. 3 weeks further time is granted to file affidavit in opposition. You file it within 3 weeks, okay?
Yes, Your Lord. Deep your.
27.
27, yes, my lord, now put the net. Yes, in the sense, my lord, the husband of the petition.
Yes.
My lord, the husband of the petitioner, my lord, instituted writ petition, my lord, claiming the pensionable petition, the stipendiary discharge, according to the series of the cases decided by case, his case was considered along with others, and it was held that he is entitled to the pension under Assam Service Pension Bill. I'll just take my lord to page 93 of my.
He passed away.
He passed away in video, unfortunately. I was a counsel in that case, my lord, but they did not inform me, my lord. Had it been informed to me, I could have made a substitution.
Okay.
So this unfortunate thing happened.
Thereafter?
They contact me after 6-7 months. Then only when there's other people known about knew about the judgment, came to know about, then I filed this writ petition. Now, my lord, by virtue of the fact, virtue of the decision of this honorable court that the husband of the petitioner are entitled to pensionary benefit under Assam Service Pension Dole. Consequently, he also now entitled to family pension, my lord. So this is my case here, my lord. So,
Yes, if the issue is decided.
This is simple issue, my lord.
In the other cases, then for the period when the husband was in service, you have to pay. The husband was alive.
Yeah.
Instruction is not here with me, Your Lordship. I may allow to obtain instruction.
No, are you disputing the fact that the issue which was initially raised
Lordship,
has been
elementary,
decided?
elementary has wrote down one letter, Your Lordship, referring to TSC.
He was a under the at the time he was under secondary. Director will already draw letter to the director of secondary.
No, that is your inter-office communication. If he says the lady has come before us, the widow, that her husband was already fighting in the court with other similarly situated persons, and in the meantime he had passed away. Issue has been decided in favor of the petitioners. That means those petitioners, including the husband, are held to be entitled to regular pension. Now the husband has passed away. Wife definitely will have the entitlement of family pension.
Family pension.
No, that is after this matter is
Yes, yes, that is
resolved.
them, my lord.
Your part will come later.
Yeah.
No, are you disputing the fact that the issue which was raised by the husband of the petitioner, along with others, have not been disposed of by this court? And have you annexed that copy of the
Yes,
judgment?
yes, my lord, may I look
Judgment
into
has
page
been
93, my lord, of my writ
Next is
petition.
your lordship.
And it is the writ petition. First is my lord, petitioner's husband case was my lord 6051 of 2021. That page 63, my. Page 63, lordship may kindly say, I will not burden my lord with other documents, my lord, but page 63.
Then what is there to be decided, madam?
Page 63.
Right now, your lordship, let me allow 1 week time, your lordship, to obtain the instruction.
6051 of
pertaining to that,
2020.
your
That is the
lordship.
husband of the.
I know that your lordship, similar cases has been annexed, your lordship. But your lordship, since I have no instruction along with.
Okay, we'll have it on Monday next.
Lordship.
It's come up for the first time after notice.
Yes,
Okay,
yes,
okay.
my lord.
Sri B.J. Ghosh, learned counsel for the petitioner, has submitted. But more than a year has passed, madam.
Yes, your lordship. I will positively, your
submitted.
lordship.
That
obtain
notice
instruction.
was issued on 5/6/2024. Until now, no returns have been filed. Para, he has submitted that the issue may not require a detailed hearing, as the same was already decided, as the same was decided in principle earlier. PLE, PLE in principle, PLE, earlier. Full stop, para. Ms. P. Das, learned standing counsel. This is for secondary education, as well as Sri G. Pegu, learned standing counsel, elementary education department. Pray for and are granted some time to obtain the instructions on the submissions advanced by the learned counsel for the petitioner. Full stop, para. In view of the aforesaid discussion, matter is adjourned to be listed on 16th of June. 16th June.
Keep you.
Item 30. Yes.
Lordship, here the petitioner is a minor lordship, and she is represented by her mother. And admittedly, she is the daughter of the second wife. of
You have
the
done the
incumbent.
cured the affidavit.
No.
No.
I have filed.
Last, the learned counsel for petition submitted there is some defect in the affidavit.
Affidavit filed, Lord.
Lordship, he, just not directed me, he.
I am for the private respondent number 6, Lord.
No, the order passed on 27/5/2025. What is that order?
Only they are his prayer.
But it has been written as learned counsel for the petitioner.
Yes. But
Okay. You have cured the
I have
defect.
cured the defect, I have refiled it.
Okay. Yes, you'd like to file an rejoinder affidavit.
no,
or-
he admitted that there is a irregularity to paying the as agreed amount, Lord. He admits. Lord. But my case is that, Lordship, he being the daughter of incumbent, he is entitled to proportional share of his family pension. So it could be receivable by her mother and natural guardian, Lord. Because she is irregularly paying, Lordship.
What is your case?
My case is that, Lordship, petitioner here, Lordship, is a minor. She being the daughter of incumbent, Lord. And her father was died in a harness. And the family version was finalized.
You're the daughter of the second wife.
Yes.
And you are fighting for the pensionary benefits.
Yes.
You said that the daughter would be entitled to
Yes,
pensionary benefit.
Yes. But there is an agreement, Lord. It was entered an agreement by the two wives that the first wife will pay
a sum of rupees 5,000 to the daughter of the second wife. But that amount was not regularly paid. So petitioner prayed before this honor court to get her professional share through her mother, the natural guardian.
Now, what is the provision?
Yes,
To-
Lordship,
to
from
for-
judgment I have Lordship.
Now, what is the
division
provision of law?
Yes, Lordship. It was Lordship, it should be finalized on the one family member's Lordship. Yes, but for who are entitled, because she being the daughter, she also entitled to the proportional share. In the some cases, Lordship, this honorable.
No, if there's an agreement between you, then we have nothing to say. But it will be given to only one person.
Yes, even to one person, but the pension amount should be disbursed in proportional share to those who are entitled.
Family pension will be given to only one
Yes,
person.
exactly, Lord.
How that person can divide it amongst her others, that's a different matter. But can it go as an order of the court?
Lordship, one judgment, division bench judgment of the honorable court.
Let us see
Yes.
what is the provision of law.
Yes.
Pension.
143, Lordship.
What is 143?
Yes. Family, family definition, Lordship, 143, Lordship.
Yes.
Family for the purpose of rules in this section will include the following relatives of the officer. Clause A, wife in the case of male officer, husband in case of female officer, minor sons, and unmarried minor daughter. This is called family law.
Okay.
Number two, in clause 2, the pension will be admissible. In case of widow or widower, after the date of her oblique, his death or remarriage, whichever is earlier. In case of minor son, until she attains the age of 18 years. In case of unmarried daughter, until she attains the age of 21 years or marries, which is earlier. So she is entitled.
What about 3?
Yes. The pension awarded under this rule in this section will not be payable to more than one member of an officer's family at the same time.
That is, how do you overcome this?
Yes.
It will be first be admissible to the widow, widower, and thereafter to the minor children.
Yes. But in some cases, this honorable court interpreted, I have the order copy.
Let us see that copy. Let us see that.
Division bench.
কোনোবা এখন থাকিব লাগিব পিয়ন Yes, what is this?
Yes, but this is division bench, but paragraph 5 onward, I am just reading. Paragraph number 5. It is now seen that the issue is only with regards to the entitlement of the minor daughter of the petitioner to the appropriate share of family pension and other retirement benefits as per law laid down in Rameshwar Deori Supra. The Supreme Court has held that although the second marriage contracted during the substance of the first marriage is void, however, minor children of the second marriage are entitled to family pension. In the instant case, Sri Punam Devi Mondal, that is response number 6, have furnished a deed of undertaking to pay back the due share of family pension and other retirement benefits to Mrs. Neha Bora, daughter of the petitioner, if she is found entitled to. The response number 6 have nowhere denied that Mrs. Neha Bora is not the daughter of late Pradeep Mandal he has only questioned the legality of the marriage contracted between the writ petitioner and late Pradeep Mandal. In the absence of any pleadings or supporting documents, the benefit of proportional entitlement to the family pension and other retirement dues cannot be denied to the minor daughter of the petitioner following the law laid down in Rameshwari Devi. Having regard to the above, we hold that the minor daughter of the writ petitioner is entitled to proportional share of the family pension and other retirement benefits until she attains the age of majority. The respondent railways shall now make the arrangement for dispersal of the proportional share of the family pension to which MS Nehaboro is entitled to. Such proportional share shall be paid in the bank account of MS Nehaboro, allowed to be operated by the writ petitioner mother until she attains the age of majority. So it was directed to disburse through her mother account.
But in this case, the provisions of sub-rule 3 was not even brought to the consideration.
Lordship, and another also Lordship, but the question is Lordship, it's regarding, I'm Lordship fairly submitting, it is a family pension Lordship, and she is a minor Lordship, she is reading in class 8 now.
No, we are not on the issue of entitlement. She is definitely entitled.
Yes.
But it is in the
But there are anomalies
no,
to disbursing.
in a manner which has been prescribed by these pension rules.
Yes.
There is a hierarchy.
Yes.
First, second, third, fourth. And there, as per 3, it says it can be disbursed to only one person.
Yes, sir.
Now, if that person distributes, there is no problem.
Yes, sir.
But
Yes.
it cannot be disbursed to
Yes,
more than
but-
one
but
person.
She is the stepmother Lordship, definitely she is doing anomalies to disbursing. That's why if this order court thinks Lordship, that can be Lordship.
How much is your family pension?
Yes, Lordship, she was a subject teacher.
Now, how much is the family pension?
Family pension, Lordship, it will
How much?
I'll confirm the amount. Lord.
No, how much are you paying now?
5,000.
Now, if you are take instructions and advise your client, then matter can be resolved here.
Lordship, he is paying, there was some irregularity in between, Lordship, but again, he has been paying since December 2020.
No, is it proportional?
Lordship, they have agreed. There is an agreement to that effect.
But they are ignorance of law, but they are, it is admitted fact on the record. They are admitted only
Lordship,
5,000.
page 17, they have annexed an
In
agreement.
proportion of Lordship,
It was
she will,
agreed
she will get
amount
more.
5,000 per month.
She will get more.
No, if it is agreed,
Yes,
you have consented,
yes, sir. Yes, her mother was consent
then
at that relevant point.
first, as per subsection 3,
Yeah.
it should be disbursed to only one person. Done.
Yeah.
Your entitlement we are not questioning because law provides you.
Yeah.
But the how you disburse should be dependent on your agreement. If you have agreed to 5,000,
Even then, Lordship, they are not paying regularly.
No, I admit there was some irregularities, Lordship, in between.
now
but
he said that it has been
yes,
paid.
we have been paying. He is also admitting.
As per my Lordship, ample prayer before Lordship, just he being
No,
the,
it's not a case that they have not been paid. There were some irregularities. Learned Council has said that those have been taken care of. And you are also admitting that yes, no. You have filed your affidavit.
Lord.
Um, where is the agreement?
yes,
The agreement is just page 17 of the writ petition.
It says 5,000.
Yes.
What is the prayer in the writ petition?
it could
The proportion. You're only depending on 3/8/2017 affidavit agreement.
Okay.
Your foundation of this case is the agreement. As per the agreement, they are paying.
Yes, Lordship, yet some area also not paid. That's it.
Arrears, we can ask them to clear within maybe 1 month, 2 months.
Then lots of this petition may be disposed of with their endorsement that they will regularly pay it, paying the
Yes.
fee, and
Hard.
area amount also will be paid.
Arrears are there or not?
Some areas, but
No, no, you can clear it. What is your age?
Lordship, her age is now 16 years.
16 years. Heard Sri Ejad Ahmed, learned counsel for the petitioner. Also heard
Ekakut.
Miss Leedas Burman, learned G. Assam, Sri B. Sharma, learned standing counsel, accountant general, and Miss P. Das, learned standing counsel, secondary education department. Full stop. Sri A. Kakoti, learned counsel, is present for the respondent number 6, who has also filed affidavit in opposition. Para, considering the subject matter and the stand taken by the private respondent in the affidavit in opposition filed on 28/5/2025, the instant petition is taken up for disposal at the admission stage itself. Para, the writ petition has been instituted with the following prayer, page 11, prayer quote Kurijiba. It is the case of the petitioner that she is the daughter of late Abu Bakr Siddiq, who was a government servant and serving as subject teacher in the Hazirhat HS school in the district of South Salmara, Mankachar. Please have your seat. The petitioner, who is a minor and represented by her mother, has, however, disclosed that her mother is the second wife of the late government servant who had passed away on 16/3/2015. Full stop. As regards the family pension, comma, it is the case of the petitioner that there was a deed of settlement dated 3/8/2017, as per which a portion of the family pension was to be paid to the petitioner, as she is also entitled to such family pension as per the family pension, as per the Assam pension rules of 1969. Para, Sri Ahmed, the learned counsel, has submitted that in spite of the aforesaid deed to capital, dated 3/8/2017, the portion agreed to be given to the petitioner was not paid regularly, and there were also arrears. Para, Sri Kakoti, the learned counsel for respondent number 6, by drawing the attention of this court to the affidavit in opposition filed on 28/5/2025, has, however, submitted that though there were some irregularities in making the aforesaid payment, comma, the same has been taken care of, and the amount agreed is being regularly paid to the petitioner. Full stop. Para. Sri Ahmed, on the other hand, though has admitted to the aforesaid aspect, has contended that certain arrears are still pending. Para. In view of the aforesaid development and also the stand of the respondent number 6 taken in the aforesaid affidavit filed on 28/5/2025, this court is of the view that the grievance of the petitioner, as expressed in the writ petition, has been substantially redressed. Para. This writ petition is accordingly closed by directing that the agreement entered into by the parties be strictly adhered to, and the arrears which have been mentioned in the agreement be cleared expeditiously and preferably within a period of 90 days from today. Writ petition accordingly stands disposed of. We'll put one line on 143 too, that it should go one by one, okay? Then it will be better. Item 31. 31.
Last time, respondent number 3, it took time to file an affidavit.
So we took
You are
time to,
3.
I'm,
3, who is you? Who are you?
I'm the AICT. I have, otherwise. I have-
AICT.
Yes. I have
What is
received,
your role?
Lordship, perhaps the prayers are a little misconceived in this petition, because otherwise my instructions are complete, my affidavit has gone for vetting. So they have challenged a requirement under the AICTE handbook for deposit of a security deposit, for opening a new Ayurvedic college. But Ayurvedic colleges are not even covered under the AICTE Act, because AICTE Act is confined to the subjects which are defined as technical education under the Act. So for Ayurvedic education, there is a new act called the National Commission for Indian System of Medicine Act of 2020. So that National Commission is the governing body for that. So otherwise, I'll base it on affidavit.
If you do not file affidavit, it is okay. That national, that has already been made party here.
Is it a party here?
Yeah, the commission is a party.
You are.
I'm going to.
No, Mr. Gogoi, you are appearing for the national. What is your stand?
Otherwise, Lordship, the
No, the grievance of the petitioner is against Mr. Pathak's client or your client?
both.
But then you will have a duty to declare.
Yeah.
Pathak will say that
he
he
has
is
no-
doesn't, then role is yours. You have to say.
And regarding pre-deposit part, as per the regulation, Lord, if he want to examine it, he have to challenge it before the division bench. Lord.
Part 3 AC Buragohai Learned Senior Counsel, assisted by Ms. Tamuli, J. Tamuli, for the petitioner. Para. Sri KP Pathak, Learned Standing Counsel, AICTE, has, however, contended that as per
Recorded, I'll file an affidavit because it is not.
however, contended that as per instructions received, his client may not be a necessary party at all. And in this regard, an affidavit has been prepared, which has been sent for vetting. Full stop. Both Sri Pathak and Sri K. Gogoi, Learned Standing Counsel, Health and Family Welfare Department, pray for and are granted 3 weeks' time to file affidavit in opposition. List after 3 weeks.
Would you not give me a date?
Okay, list 3 weeks. We'll have immediately on the reopening. We'll have it on 18th of July. List on 18th July. You get enough time, file it before that.
Obligement.
Item 25.
In this cases, PPC is supposed to file an affidavit. I have received my instruction but the inspection is not complete, my lord. So some more time will be required for filing the affidavit.
Lordship. Affidavit will be required.
Okay. Last chance. How many last chance limit is there?
It was just 10, my lord, for vetting, but thereafter some clarification is sought, my lord, because some the inspection is not clear, my.
Okay. Similarly situated, but they have only in the application form, they have not written the subject.
Yes, that is the issue, my lord.
That is the only issue. And but similarly, situated, marks have been allotted. Sri S. Bora, Leonard, Standing Council BTC, as well as Sri R.K. Musari. Do it anamically. S. Bora, as well as Sri R.K. Musari, Standing Council BTC, have submitted that affidavit in opposition have been prepared, which and sent for vetting. Full stop. Sri also heard Sri PD Das, Leonard Senior Council, comma.
I mean,
In item 35. Well, say, comma, Miss B. Bhuyan, Leonard Senior Council, and Sri B.D. Deka,
PM Decca.
BM Deka, Leonard Council for the petitioners, who however express urgency in this matter. In these matters, express about express urgency in these matters. Considering the above, time of 2 weeks is granted to file the affidavit. List on, we give a date.
Lordship, give a date. After the
List
holiday.
on,
No, after let it be after petition, my lord. Since the person has already been appointed, all this.
list on 16th of July. 16th of July, is there any interim order?
In my case, there is an
Interim order, comma, if any, shall stand
in item 35.
extended till the next date of listing.
What's all?
Chaudhary for whom? Yeah, MK Chaudhary, yeah? You are also there? What is your name? MK Bora, MK Chaudhary, private restaurant, MK Bora, state, on behalf of JK Goswami. Record group.
Ideas 36 and 37.
May I please, Lordship?
Yes.
Lordship. Today morning, your lordship, we have filed our affidavit. That is not come to the records, your lordship.
Have you been served? Have you been served?
No, yes, Lordship.
That's okay.
Right.
Yes, P. Das, Leonard, Standing Council, Secondary Education Department has submitted that the affidavit in opposition has been filed this morning, which however has not been tagged with the records. Para? Three.
MK News.
MK New, Leonard Council for the petitioner, acknowledges receipt of such affidavit and prays for some time to file rejoinder affidavit. Para? List after 4 weeks to enable filing of such rejoinder affidavit. Okay, 3 weeks. 3 weeks.
DPO.
Until 38.
Mr. Goswami?
As per last order, government was supposed to file affidavit.
Yes, madam.
Inspection is evident.
It's a long pending matter.
What is the matter about?
Matter is okay, petitioner was appointed as stipended teacher in 1999. Thereafter, he was transferred to the Nalbari district from BTC area. All the person,
Initially, where were you?
okay,
Initially, where were you?
originally in Tamulpur,
Tamulpur to Nalbari.
Nalbari.
Then,
Thereafter, look at the petitioner was receiving salary up to 2006. Thereafter, salary has been stopped. Government has issued notice regarding inquiry. Inquiry was conducted. Inquiry has said that the petitioner name reflected in the both two lists. One is irregular, one is legal. Both the petitioner name has been reflected. Thereafter, also no decision has been taken. Thereafter, government has issued 2 cause notice to the petitioner. Petitioner has submitted reply. Nothing was communicated. In some cases, they have terminated service. That was silent. But in case no termination order, petitioner continued service. Thereafter, petitioner has approached this honorable court of the direction that they should take a decision. This honorable court pass an order directing the authority to pass a final order regarding the decision. Ultimately, they have passed a speaking order whereby they have said that petitioner has not reported before the inquiry committee, and that is why petitioner cannot claim any area salary or salary.
okay, madam, your affidavit, very good.
And till that petitioner is continuing in service without celery. And Lordship, one thing, in BTC area, there is a case before this honorable court, and before the Reed court, they have taken a decision that those are getting salary up to 2006, they will be given full salary and their service will be regularized. Accordingly, all the person is getting salary in BTC area. But my case, I have been transferred to here.
Okay. First, we ask Rustam Leonard counsel for the petitioner, who has submitted that till now the issue regarding payment of his arrears salaries has not been resolved. Para? Miss S. Chutia, Learned Standing Council, Elementary Education Department. However, prays for some more time to file the affidavit in opposition. Para? Accordingly, matter is adjourned to be listed on July 18th, by which time affidavit in opposition is required to be filed. On the first week after the vacation. Yes. 18 July.
My lord, in this matter, my lord, I am led by Mr. K.N. Chaudhary, my lord. He is on legs in court number 24. So may I pay that the matter may be fixed on next Tuesday, my lord.
Next Tuesday.
Yes, my lord.
What is there in this matter?
My lord, we are paying for extension of our service to the 65 years. On the basis of
How
an
can you
cabinet
do?
decision, my lord.
Can you do?
Next Tuesday, my lord.
What on university is it possible? And you have a status quo order. Yes.
Not break. Otherwise, my lord, according to us, my lord, he is an employee of the, I mean, she was an employee of the government of Assam, my lord.
We have seen the facts.
But
Okay.
not further.
On the prayer made on behalf of Sri K.N. Chaudhary, Learned Senior Counsel for the petitioner. Matter is adjourned to be listed next week.
17th, my lord.
We will see next week. Let's see.
Right, and deep law, like. Deep.
May I please, Your Lordship? In this case, Your Lordship, what has happened, the petitioner who was a block elementary education officer, Your Lordship, he was arrested in connection with a case, Your Lordship, by the vigilance ACB, Your Lordship. And thereafter, if Your Lordship comes to Your Lordship, page 21.
Yes, madam.
His suspension order was timely reviewed.
Reviewed.
That, Your
And it
Lordship,
is
we have not been furnished with any review order, Your Lordship.
During hearing, my lord, it has been received by the petitioner review.
Lordship will kindly see what has happened. Your Lordship will kindly see the date of order, Your Lordship, suspension. And in fact, Your Lordship, disciplinary proceeding is also complete. They are not passing any order, Your Lordship. Evidence, etc., everything has been taken. I have cross-examined, Your Lordship. And in fact,
You file affidavit.
Lord,
It says that you are given in hearing, a periodic review was also held.
that, Your Lordship, let them
Let
file.
them file affidavit,
Lord.
better for you.
Hearing was complete, Your Lordship.
No, not on the DP.
Lordship.
Not on the DP, on
Lord.
the aspect of revocation of the suspension. That they have said.
Lord.
And you complete the DP, matter ends there.
And if they have passed, Your Lordship, heard the matter so far as my withdrawal of my suspension, they should have produced the order on that, Your Lordship, before this honorable court.
Oh. Heard Sri as Bothakut Learned Counsel for the petitioner, who is aggrieved by continuation of a suspension order which had occasioned because of the arrest of the petitioner in a criminal case in which he was in custody for more than 48 hours. Para, the principal ground of challenge is not conducting of any review within the time specified. Para, Ms. S. Chutia, the learned standing counsel. This is what elementary education. Elementary education department has, however, submitted that periodic review were held from time to time in which the petitioner was heard and such review orders were also furnished to him. She has also submitted that in the connected departmental proceeding, she has also submitted that the connected departmental proceeding is on the verge of completion, as the inquiry officer has already furnished a report. She has placed before this court copy of an order dated 13, what is this, 13/5 or what? 13/5/2025. Full stop, para. Sri Bothakur, on the other hand, has refuted the aspect that any review meetings were held in which the petitioner was present, and has contended that no orders of any such review proceeding were furnished to him. Para, let the department file an additional an affidavit in opposition incorporating the contentions advanced today, as well as all other relevant facts. Full stop. Such affidavit be filed within a period of 4 weeks. 4 weeks from today. List this case. We'll put a date. List this case on 16th of July. A copy of the order dated 25 or 13, is it 13/5? 13/5/2025 is made part of the records. It will like we said the order should come on my device. Not a about.
41. And this is a CRT manner. Some more time for getting the instruction.
41.
95 said.
On the prayer of Sri S. Bora, learned standing counsel SCRT. 4 weeks further time is granted to file affidavit in opposition.
Top man at elementary department. They are the main part.
Madam Fukan will say you will also need time. Both Miss N. Fukan, learned standing counsel elementary education department, and Sri S. Bora, pray for and are granted 4 weeks time to file affidavit in opposition.
That may be fixed. My service has been terminated.
List immediately after the summer vacations.
Relating to non-payment of family welfare of an unmarried daughter law.
Here, madam, I am praying for 2 weeks time to receive instruction, madam. Earlier occasion, director returned letter to the DO. DO has submitted the report, but that report was inadequate. So can you grant 2 weeks time?
Okay.
in
Or
DH
Sri M. Khan, learned counsel for the petitioner, whose grievance is non-receipt of family pension. Full stop. The petitioner is the unmarried daughter
My lord, this is unmarried daughter. Yes.
Unmarried daughter of the deceased government servant. Para? On the prayer of Sri G. Pegu, learned training council,
Yes.
elementary education. 3 weeks further time is granted to file affidavit in opposition.
My lord, any date may be given.
Sri D. Bhattacharya, learned standing council AG is present. List immediately after the summer vacations. You get enough time, file it. Is anyone getting Mr. Khan?
Lordship,
Who is getting family pension? Nobody.
no. Only unmarried daughter.
No. Is who has passed away?
Father.
Your father. No. Is your mother alive?
No, mother expect prior to death. Prior to death
Then
of mother.
there is no question. No, should not be any dispute of her.
Only gratuity amount and GIS
Unmarried daughter would be
lease
entitled.
dependent relief.
All right.
Literally.
This petitioner were appointed as computer operator, this assistant, second officer in the year 2017. 2021, service was terminated and pursuant to the High Court order, my lord, they were reinstated and they were allowed to continue as a contract. Now they are not getting salaries from November 19 to June 21 and thereafter from October 24 to till date. Now what they say in
Which
the affidavit,
Which department?
science and technology.
Which department? Science and technology.
Science and technology.
Mr.
My
Tamildar?
lord, in their affidavit, what they say is, your lordship will kindly see page 56, paragraph 10. Other contractual workers are getting it. They said we are going to create a fund. Then thereafter they will try to do something. So how long they will have to sustain their highly qualified persons? Right?
How can you treat them like this?
Well,
If you are utilizing their service, you need to pay them. You will form a fund, then pay by this time.
Correct. Today, the principal has allowed to rejoin the petitioner on protected basis. The director has, the principal has written a paper to the director asking to fix the pay or anything the pay. But the director in his reply said, because the director is nowhere the responsible for their appointment also, and that for paying the salary also. So please come to the page 33.
You appear for whom?
I appear for all the principal of the JSP and director.
Then you cannot take two different stands.
So we have down.
If you appear for the principal, you can take the stand. Now it appears that there is a conflict of stands taken by the principal and the director.
So now the GP has taken a resolution at page 56. My senior pointed out that once the fund will be available, then they will pick it.
Now when will the fund be available? That is the question.
That the principal will be to next year.
You take steps, and they have been continuing in the strength of the court's earlier direction.
They were allowed to
reappointed.
Once you are utilizing their services,
on contracted basis.
If you think that the services are required, utilizing, there is an obligation. You cannot shy away from your obligation.
The respondent, the principal will be the best person to look when the.
You are the principal.
Yes, when they will the fund will be available. That is right.
You are the principal.
That's not.
Then that is why you are asking repeatedly, whom are you representing? You are representing all of the respondents.
To that effect, I don't have put when. Paragraph 10, last part.
Heard Sri Bididas Learned Senior Counsel for the petitioners. So in this case, notice was issued on, this is the first time after it has come after notice. In this case, notice was issued on 21/5/2025. Para Sri A.R. Tamildar, Learned Counsel, Learned Standing Counsel, Higher Education Department, who has appeared for all the respondents, has submitted that some time may be granted to enable him to take appropriate instructions as to when the funds would be available. Clara? Be that as it may,
From
comma.
November 19 to
Be that as it may, comma. Since it is not in dispute that the services of the petitioners are utilized, comma. The respondents are duty bound to make their payments. Full stop. Therefore, while time is granted to obtain instructions, comma, a direction is issued to immediately arrange for the funds so that for the present, the current salaries of the petitioners can be paid. Full stop. Let such instructions be brought on record on the next date. Full stop. List this case on.
So 1 week.
Today is the 9th. We'll have it on 23rd. 2 weeks. You get 2 weeks time.
Respondent number 4 may be the direction to respondent number 14.
All the respondents.
23rd. 23rd.
23rd.
Okay.
44 and 45. 44 and 45, yes.
Okay. Malad, here, I don't know, 45 is a review, Malad, preferred by the state. And 44 is the contempt.
Yes.
So review, I have preferred the review, Malad, seeking review of the order to 28/11/2018. My lord, would find the order under review at case 46. The opposite party number 1 writ petitioner preferred the writ petition, my lord, challenging the provincialization order of the respondent number 6.
Okay.
The state writ petition was finally allowed, my lord, by holding that petitioner was senior to the respondent number 6 and he should get the benefit of provincialization.
You are the petitioner in that case.
Yes.
Okay.
And
right.
against the state order, my lord, they have preferred and heat appeal also. And that was also
Now, what was the
respondent
direction?
number 6 actually preferred and
What is the direction here?
The direction, my lord, kindly come to page 52.
5-2.
5-2, paragraph 15, my lord. May, in view of the above, the judgment and order dated 31/8/2016 passed in WBC number so and so would hold its force and the provision thereof that for the purpose of provincialization of assistant teacher science, the basis would be seniority and not the subject combination would also have to be followed. In the event the said proposition is followed, the petitioner is senior to the respondent number 6 in the manner as indicated above. It being so, the court is of the view that the order of provincializing the service of the respondent number 6 would have to be declared to be contrary to the requirement of Section 4 of the Act of 2011. Having declared so, it is directed that the Director of Secondary Education, Assam, would pass necessary order thereto by taking into consideration that the petitioner is senior to the respondent number 6. And being senior, the provision of Section 4 of the Act of 2011 would be applicable in favor of the petitioner. In doing so, the director shall follow necessary procedure under the law as required. While dealing with the respondent number 6, it is further provided that in the event the provincialization of the respondent number 6 is withdrawn, the benefit of that had already been accrued to him shall not be recalled, and further the case of the respondent number 6 be again considered under the provision of Section 36 of the Act of 2017. So, my lord, our only ground for review is, my lord, while this order was passed, my lord, at that time, my lord, the Act of 2011 was struck down by this honorable court. So, while we have considered the case of the petitioner, my lord, so now we cannot give the benefit of Act of 2011 since the Act is no longer in existence, my lord. Because this order was passed in the year 2018. And the Act of 2011 was struck down in the year 2016, my lord, 23/9/2016. So this order was passed on 28/11/2018. So that aspect of the matter was not considered while deciding the.
But what about this for number 6? Has it been withdrawn?
Yes, well, that was withdrawn, my lord. That was withdrawn subsequently. My lord, though notice was issued to respondent number 6 in this review petition, my lord, I think, my lord, he has not, till date, he has not appeared, my lord.
My
So
lord,
far as the provincialization benefits given to the respondent number 6 is concerned, you have withdrawn.
That is withdrawn, my
And
lord.
so far, the aspect of giving him benefit, that you could not do because at the time when this judgment was passed,
Yes, my
the
lord.
Act of 2011 was no longer
No
in
longer
existence.
exists, my lord.
Yes, Mr.
then my lord, whatever, my lord, in the at the review petition, they have not mentioned regarding the writ appeal, which has been filed by the
No,
respondent number 3.
no,
That was dismissed way back in the year 2021. Nowhere in the review petition it was.
no, how that so? See, Mr. Khatoniar has very clearly admitted that the judgment had two aspects. One is taking back the benefits given to respondent number 6, which has been done. And the second is giving you the benefit under a particular scheme of an act. Act is no longer in existence, not today, but even at the time of passing of the judgment in the year 2018. Act was, had, 2016 itself. And don't you think that is a ground of review?
But thereafter, they have referred a writ petition also. Actually, my lord, I don't have the copy of the order.
You had filed writ petition
Respondent number 6
regarding?
regarding challenging some order.
No, the filing of the preferring of the appeal by the respondent number 6, though may be a relevant factor, though may be a connected factor, it may not be very relevant to the grounds of review. First, they were not the appellant, but that is not the point. Whether they are appellant or not, they should have disclosed. But non-disclosure, will it affect the decision-making process? The question of relevancy would only come when his non-disclosure becomes relevant. Even if an appeal is dismissed or affirmed, since it has been contended and also admitted by you that those benefits have been withdrawn, but whether will be entitled to a benefit.
My lord, here in this case, my lord, I only pray for 2 weeks time to file my affidavit in respect of review. Some more documents I require.
Has it come for the first time review?
Not first time, but second or third time, my lord, because
Maximum
earlier,
time
my lord,
letter, man,
earlier, my lord, the notice has not been started upon the response. Certainly, it was started, my lord, but
Heard Sri N.J. Khatoniar, Learned Counsel, Learned Standing Counsel, Secondary Education Department, who by means of this application has prayed for review of the order dated ... passed in WPC ... Full stop. It is the primary contention advanced that the aforesaid order had two aspects. First off, firstly, to withdraw the benefits of provincialization given to the respondent number 6 under the 2011 Act, and secondly, to confer such benefits upon the petitioner, writ petitioner, opposite party, as he was held to be senior to the respondent number 6 in all respects. Full stop. He has submitted that so far as withdrawal of the benefits to the respondent number 6 is concerned, the same has been done. Full stop. However, the benefits of provincialization could not have been directed to be done by the aforesaid order of this court, inasmuch as the 2011 Act was struck down to be ultra vires by this court, by a division bench of this court in the year 2016 itself, which was even prior to the present order was passed in the year 2018. Full stop. On the other hand, Sri S. Das, M. Chanda, S. Chaudhary, Learned Counsel for the opposite party writ petitioner has contended that against the order in question, an appeal was preferred by the private respondent, which was dismissed, and this fact has not been disclosed in the present review petition. Full stop. He has submitted that since the order has attained finality, comma, review is not maintainable. Para? The he submits that he would be filing an objection to the present review application, for which he prays for some time. Para, in view of the above, how much? 3 weeks time is granted to Sri Chaudhary, the learned counsel for the opposite party, to file objection affidavit.
To clarify this, I have disclosed it on paragraph 3, that paragraph.
Okay, we'll see.
Obliged, Lord.
এটা লিখি দিবা last না Sri Khatanir, the learned standing council has however clarified that disclosure of referring of a writ appeal by the private respondent and its dismissal has been mentioned in the review petition.
Obliged, Lord.
Has been mentioned, has been done. Disclosure mentioned, disclosure done. Okay, next.
46.
Mr. Sharma.
My lord, this matter relates to, my lord, release of family pension amount and provision fund.
He has received everything.
I have instruction that, my lord, he has received the family pension amount. But provision fund is not released.
Lord, my instruction is that SCRT directorate has forwarded it to the government. Till that there is no response. Lord, may allow me a short time. I'll try to get why it is pending or it has been spent.
Heard Sri J. Sharma, learned counsel for the petitioner. First of all, also heard Sri B. Chaudhary, learned
Standing
standing by SCRT,
Yes.
as well as Sri D. Bhattacharya, learned standing counsel, accountant general Assam. Para? Sri Chaudhary, the learned standing counsel, has submitted that family pension, that the principal issue relating to non-receipt of family pension has already been redressed in the meantime, and such family pension has been released to the petitioner. Full stop. The said aspect has not been disputed by Sri Sharma, who however contends that the provident fund amount has not been released. Para? Sri Chaudhary, the learned standing counsel, on this aspect prays for time of 2 weeks to obtain instructions. Para? List after 2 weeks.
My lord,
List on 25th of June.
Obliged.
27.
The order of 18/1/2023. Till date, date 23, it has not been complied.
Yes, Mr. Kaushik. Attorney?
I'm praying for some time, Lord, because he's preparing on the case.
No, you said that last time the proposal was sent to the government.
And my lord, take 3 weeks time to complete the entire process.
Heard Sri Amar Khandakar, learned counsel for the petitioner. Para? On the prayer of Sri N.J. Khatunir, learned counsel for the respondent. Two weeks further time is granted to enable him to obtain instructions regarding the outcome of the proposal said to have been sent for creation of post of language tutor, which fact was recorded, which submission was recorded by this court in its order dated 14/5/2025.
Say date, my
We said how many? 2 weeks, no?
2 weeks.
2 weeks.
Any date, my lord, after.
Let it be 2 weeks, let's see.
I am
48.
Against the we prefer to get this petition, and now we file one appeal yet soon after filing real.
But will those be grounds?
Ground lordship, here is lordship, so we directly pay interest and lordship,
Miss R.B. Bora, learned counsel for the respondent has submitted that though the application for review of the order in question dated 23/3/2023. No. Ms. R.B. Bora, learned counsel for the respondent has submitted that though a review was preferred against the order dated 23/3/2023 passed in WPC 183 of 2016, the same has been dismissed. Full stop. However, an writ appeal has been filed, which is pending consideration. Full stop. Para. Though mere filing of an appeal may not be a defense not to comply with a court's order, comma, in the interest of justice, adjudication of this matter is deferred by 2 weeks. Let us see, 2 weeks. We will not give you that much of liberty.
49.
May I please, Your Lordship? Lordship, this is for non-compliance of the order dated 19/10/2023, Your Lordship.
Yes, who is appearing?
Lordship, in the last order, Your Lordship may peruse, Your Lordship. Order dated 23/5/2025.
Yes, we have seen.
Yes, Lordship.
Need some more time, but the process is going on.
On 23/5/2025, when this matter was listed, comma, it was recorded that there was substantial compliance of the order in question, except for the aspect of payment of arrears salaries from December 2009 till the date of termination from service.
Lordship, 3/10/2017, Lordship, typographically it is admitted.
3/10, till the date of termination of this.
Your Lordship may record it.
Yes,
Otherwise.
What is your name?
H. Muzumdar, Your Lordship.
Sri H. Muzumdar, learned counsel for the petitioner has, however, contended that in the said order, the date of termination has been wrongly recorded as 3/10/2013, which should be 3/10/2017. Para. Be that as it may, comma, on the prayer of 3 S. Learned counsel appearing for the respondent, 3 weeks further time is granted. Husband 1 is granted to obtain instructions on the aforesaid aspect. Said Sri Sheikh Mukhtar, learned counsel, is present for the respondent 2.
Lordship, may I pray for a date, Your Lordship?
2 weeks we have said. Let's see. Yes, next.
Be present.
Mr. Bothakur. 50. Madam, you're appearing.
Yes,
50.
madam.
50.
Yes, my lord, this is regarding
Your name is not there, madam.
50.
58.
Oh, sorry, my lord, 58.
50. Yes, Mr. Bothakur. None appears for the parties on call. Para, in the interest of justice, list after the summer vacations. Okay, Aruketas. After the review, what there is a review also. Okay, we'll have it after the recess.
It was the last order method where they submitted that it will be placed before the next DLC in May 2025. Accordingly, my lord, the time was granted till let's say there are two.
Lord, if here we have received an instruction, department has taken the step for next DLC. The DLC will be held in a short time. Okay.
When will the
Heard Sri M. Dr. Learned Counsel for the petitioner. Full stop. Also heard Sri So-and-so Learned Counsel appearing on instructions of Sri D. Nath, Learned Counsel for the respondent, that the next DLC would be held shortly, and he accordingly prays for some time to apprise this court regarding the outcome of such DLC regarding the outcome of such consideration, of the consideration of the case of the petitioner in such DLC. He has also placed before this court copy of the written instruction dated 31/5/2025 para. In view of the above, the matter is adjourned by 2 weeks.
So to kindly make it 4 weeks.
Adjourned to then we give a adjourned to be listed immediately after the summer vacation. To P. N. Sharma.
Respond to one. Artha. Alfred.
बात तो कैसे नाम
In
पहले नाम लिखो बोलो
Yes, I appear.
Yes.
Item 52, my lord. I appear on behalf of Jay appear in my lord. I have checked the office note, my lord, as per office note dated 2019-2025. Service awaited in respect of toll rate.
Why do you mention this matter when on 4/4/2025 you are absent?
My pain, my lord, I was not.
No, this practice, we have to stop this practice of mention memo. If this is abused in this manner.
He could not come today, my lord.
No, on 4/4 there was no representation. Then you had the audacity to file a mention memo
I have
for
checked.
listing the matter.
I have checked
And today you are seeking time.
on his behalf.
Where is he?
He could not come from the Unamu.
Though this matter has been listed on the strength of a mention memo filed by the petitioner, comma, today a prayer for adjournment has been made by Sri N. Sharma on behalf of the counsel for the petitioner. Full stop. This court has also noticed that on the last occasion, that is 4/4/2025, there was no representation on behalf of the petitioner. Pursa. The practice of getting matters listed by filing mention memo, irrespective of the urgency involved, is highly discouraged. Further, there was no reason to file a mention memo with today's date given therein for listing and thereafter seeking adjournment. Para, such practice is deprecated and the learned counsel involved are directed to maintain caution in this regard. List after the summer vacation.
In this case, for restoration of the writ petition, which was dismissed for default.
Writ petition or review petition?
Writ petition. It
Writ.
is a writ petition by the state against an order of the Assam Administrative Tribunal. On that particular day, I was engaged on legs in another court. Since the matter was marked to me, none else appeared in the.
Where is the order?
My lordship will find the page 10.
Matter.
Yes, ma'am. So there were developments thereafter, and there was a stay in the matter also on the payment of the salary. When we moved the matter, there was also a stay. The lordship has page 12, matter the cause list for the date page 13. Serial number 11, my lord. So,
We have to issue notice.
Matter was dismissed only a month ago.
We have to issue notice.
3rd of April 25, it was dismissed.
Heard. Sri R. Majumdar, Learned Standing Council. Elementary Education Department. Who by means of this application, has prayed for restoration of the connected WPC 2981 2015, which was dismissed for non-prosecution on 3/4/2025. Footstep. Issue notice. Returnable by 4 weeks. Let notice be served upon the respondents by registered post with AD. Steps within 2 days, 2 working days. 2 days. Yes, I'm obliged. What is this review?
Second appeal, my lord. One application was filed under section, my lord, order 41 rule 26. That was, my lord, although after filing that application, my lord, other side taking time to file objection, no objection was filed. And even then, my lord, that was without, my lord, properly considering that, my lord, the petition was, second appeal was decided.
Where is the order of this court?
My lord.
Where is the order of this court?
Please, my lord. Page 11, my lord. Page 11, my lord. It was, my lord, plaintiff, it was decreed, my lord. And against that, there's a appeal filed by defendant, my lord. And defendant, my lord, the defendant appeal was allowed. Against the reversal order, my lord, it was dishonorable court. Some document to resell it, my lord. That was, my lord, certified copy was produced before this court. And now he filed an application.
Now
for...
this, why this review is pending since more than almost a
No,
year?
my lord, there's a defect, my lord. Probably there's a defect, my lord. Defect in.
Are you really interested?
my lord.
in this review. Are you interested in pursuing this review?
Uh,
1 year you did not even take care. Where has the review gone?
Now, my lord, actually, they are not taking, they are not worried because they landing in their position. So only for confirmation of position. Because my title derived from the two sale deed. And these two sale deed, my lord, we just issued a, my lord, certified copy to the police before this honorable court. Now I got the, my lord, original copy, my lord. That's why, my lord, order 41/27 filed. So let notice be issued, my lord. I'm
Now, what are your grounds?
Gown, my lord, your lordship kindly see, page, my lord. Page 6, my lord. Gown numbers B, C, my lord. B and C, my lord, probably.
Page 6,
Page 6, my lord.
round number B.
Gown number B, C, and also I like to place E also, my lord. Because sometime, my lord, it was section 79, certified copy also take to be taken to be a consideration, my lord. While I exhibit, my lord, certified copy, they have not been objected and there is no cross also. At present, not finding any difficult. In future, it will be difficult, my lord.
You said that an order 41 Rule 27 was pending.
Not, actually, it has to be taken care of, my lord, while at the time of hearing, my lord.
No, that was pending before the time of, at the time of adjudication of the second appeal.
Yes, my lord.
That was not taken into consideration. Where is the projection that was pending? In the judgment?
Judgment. There are 20, no? Probably only discussion on para 23, my lord. Page 18, my lord. Page 23. Page 18, para 23.
Where is your application under order 41 Rule 27?
That is, I have annexed, my lord, page 75. In fact, it was registered as a IA 102 up to 20.
RS of 2009.
My lord.
And you filed order 41 Rule 27 in 2024.
Oh, no, in my lord, yes, in second appeal, my lord. No, why I am submitting, my lord? My suit was allowed. Suit was decreed. And I certified copy, I produced before this honorable court. It was not even, I was not even cross-examined by the defendant, my lord. I was not
We
cross-examined.
don't find there are grounds, but still will issue notice.
Only notice, my lord.
Third, Sri T.J. Mahanta Learned Senior Counsel, assisted by MSP Bhattacharya for the applicants who by means of this application are seeking review qua the judgment and order dated 26/20/24 passed in RSA 112 of 2009. But we have said that possession is respective possession is upon the respective parties. There is no dispute.
Yes, it is. I want confirmation of position that the defendant disturbed. In fact, they file a counterclaim. That was also rejected, my lord.
Okay, that's what he has.
By the appellate court.
কি করলো? Full stop. The principal ground of seeking review is that an application which was filed under Order 41,
Rule 20.
Rule 27, CPC for adducing additional evidence at the appellate stage was not duly considered.
My lord, that is my.
Full stop. Let notice be issued. Returnable by 6 weeks. Let steps be taken for service of notice upon the sole respondent by usual process.
My lord, deeply.
Steps within 2 days.
Yes, sir. Deeply.
May I please the question?
Yes.
Social service is already completed, my lord, as per office note. Non-appeared.
Yes, education department. Anyone from the education department? Any state council? What do you say? Can you inform anyone from the education department?
Yes, ma'am.
Please come back.
56 also similar.
Served.
Sir, my lord, already completed.
Okay, get somebody from the education department.
This report await. I on behalf of David.
Await service report. List after the summer vacations.
May come up on Friday, my lord. I wait for some time to put there.
Now you file affidavit. We'll grant you
Because
some time.
examination will be held on 17th, before that, my lord.
What examination, madam?
LLB 10th semester examination.
Okay. What is the issue involved?
Issue, my lord, the petitioner is an LLB student, my lord, 5-year course. So in 2023, November, she appeared in 10th semester repeat papers, my lord, but the results were not declared. So she remained in constant touch with the authorities, and they did not give proper answers. So she started.
Okay, you get the instructions if there is. Okay.
That is why she again filled the form, my lord, for example.
Okay. First, Miss S.B. Chaudhary, learned counsel for the petitioner. Full stop. Para. Sri P.J. Fukan, learned standing counsel, Guwahati University, however, prays for some time to enable him to obtain instructions. Para. As urgency has been expressed on behalf of the petitioner. Raise this case on Friday.
13th.
13th. Yes, anyone there?
Let I inform SMT Chistin over telephone.
Yes, Mr. Sisti, two matters where services notices have been served, not appeared.
I'll let them.
You get the instructions. We will not direct you to appear.
Yes.
We'll have this matter on Friday.
Yes.
Okay.
HL Ashkan.
Sri H.L. Laskar Learned Council for the petitioners. Has submitted that the sole respondent has been served, in spite of which none has appeared. Para, in the interest of justice, matter is adjourned.
In 56, I have did call. Today you have to keep. Yes, I forgot.
In the interest of justice, the matters are adjourned to Monday next. Next.
Yes.
Both the matters, okay?
Yes.
Separate orders, Maribu.